it is a mistake to suppose, by just citing MP or one or two judgments, that the moment any government minister or chief minister is involved, automatically this very well and old and long established jurisprudence about governors having extremely limited circumscribed powers to act in their discretion, so-called discretionary powers, is automatically overridden. So the Constitution says, and Shamsher Singh remains the bedrock, says that the discretionary so-called exceptional powers of the governor are so limited and so specific. You now read onto it a proviso which is not there anywhere in no case law, and it's a misreading of both Shamsher Singh and of MP to suggest that there is. You engraft upon it a proviso to say the moment automatically, and I repeat the word automatically, a chief minister is involved, you must assume that the advice of the council is biased and engraft the discretionary power. That is not what either Shamsher Singh, MP says. Does not. It's a much more nuanced law. The nuance is that the law remains the same. The governor has no discretion because it is not part of his list of discretionary powers. Obviously, we are not dealing with the discretionary powers. Those are different areas. So in the normal course, the governor has no power. However, if it is shown, and the word shown is important, that in a particular case of sanction, the order denying or recommending no sanction suffers from transparent apparent bias, that is to be demonstrated. And the second thing was completely forgotten in the respondents' arguments last in the manifest irrationality. So there is no auto. But I come as a slotting machine, I'm a chief minister, there is a cabinet, therefore auto. MP, you must straight away ignore, and the governor is free to act. No. The governor has to demonstrate that I am now acting in my discretionary powers because of this apparent shown bias. Shown means prima facie shown. Yes. And second, where there is no bias shown, and this is one case, and MP is very interesting, not a case of bias at all. The case went on, the demonstration that this order suggesting no sanction, words are, is manifestly irrational. Once you demonstrate that, then your discretionary powers come in, is the nuance point, much more nuanced than the generality of what was argued. That look, I have told you this is a cabinet, this is a chief minister's case. No such concept. We straight away apply. That I'll be demonstrating, Manus. The third aspect I'll be demonstrating is that your lordship has a very interesting order. According to this short point which I'm now saying is sufficient to set aside the order. I'm not saying your lordship will set aside on only one point. I'm just saying it is sufficient. It's so important. And it should be given its due importance. Well, it's without prejudice to what I'm saying about the nuance of Shamsher Singh and MP police establishment. Without prejudice to that, the entire 5-6 page order of the governor, impugned, is only on one point. I am deciding independently. I am not bound by you, the order. Entire, I repeat. So the most important part of this case, if your lordship were forced to single out the most important part, is that for a minute, if your lordship accepts that he is not bound, without me conceding at all, I am always very heavily opposing it, but that he is not bound. The governor has not gone beyond those 5 pages to add a word as to how, not being bound by these people, I find how, what, when, or where the CM is complicit, prima facie, and therefore I grant sanction. His role, that is the CM's role in this file, the CM's decision on that day, the CM's ministry on that portfolio, the CM's file noting on that particular event, nothing is to show prima facie complicity, but I grant sanction because I'm not bound. The Honorable Governor, therefore, commits a very serious constitutional sin of answering a very important constitutional question by the answer, why not? The Constitution asks him to say why, not why not. Your Lordship knows what is the why not versus why conundrum.
Yes.
Why not grant? We'll see. Sorry, that's not the constitutional thing with this. You have to show affirmatively why your Lordship should be. Your Lordship doesn't decide matters by saying why not. We allow or why not we dismiss the petition. Your Lordship is forced to give reasons for this as to why. So that's the test. On this short point, Wallace, the impugned order is liable to be set aside because it does not address the question. It does not deal with it.
No.
Now, the fourth point.
One clarification.
Fourth point.
You said that the governor has passed the order without arriving at a conclusion that the cabinet was biased, or without even observing,
without any material,
without any material to show
says
that
it is. I'm sorry to interrupt, my lords. He does say this part he addresses.
Yes.
The other part he does say the cabinet is ultimately the cabinet headed by CM. Therefore, it must be biased.
So no, he presumes it to be biased.
I'm very grateful. Presume is the right word.
Presumes it to be biased. There is a concept of unconscious bias or subconscious bias.
Maybe.
Now, which cabinet will tell their leader to be proceeded against?
Well,
Which cabinet will approve, saying that yes, he is our chief minister, governor has sought opinion of the cabinet, and this cabinet is going to permit sanction or approval for proceedings or sanction for prosecution. Which cabinet will do that? Which cabinet will go against their leader?
No.
So this, if not apparent bias,
Yeah.
or rational apprehension of that bias may have led.
May
but
I-
that should be reasoned out, is what.
May I answer?
Yes.
So first part is not reasoned out.
Yes.
First part is that. But second part, your Lordship query is more important. Well, then, if your Lordship were to accept that as a principle, then it is a case of presumptive bias. Then your Lordship is not doing, kindly see what your Lordship is really doing. I'm answering my Lord's query on an argumentative basis. My Lord has put a very important
No, there
question.
was a clarification.
No, it's a very important question. But just see, suppose your Lordship's formulation as a question
Only
to me,
clarification.
only to
What-
elicit from me. Suppose your Lordship's formulation was correct. Just for a minute, obviously your Lordship is not giving any, your Lordship is only
That's true,
discussing. Suppose your Lordship's formulation was correct. It would mean exactly what I said in the previous sentence.
Why not?
Presumptive assumed bias in every case. Well, tell me which case your Lordship will have of a sanction where your Lordship will not have to apply this principle. But the law, the constitutional law is not that. Because your Lordship then has the moment, then what is your Lordship doing? Then my Lord has in the Constitution, A, B, C, D are only 4 discretionary powers of the governor. My Lord is making this a fifth category. Always. Always. Then, Malus, why does MP go on? MP, Malus, doesn't go on the bias. If presumptive bias was correct, it had to be finished. It goes by analyzing that the reasoning of the cabinet is not right. It is manifestly irrational. And it is not irrationality, manifestly irrational.
A little higher pedestal of irrationality.
I'm very grateful.
Like how it is arbitrariness and manifest arbiter.
So, Malas, I'm very grateful, in fact, for the clarificatory question. The only case chosen by the Honorable Governor to cite is MP. But I've analyzed MP very carefully now, Malas. I hate to say this, but possibly the Governor has not been assisted sufficiently, he's not a lawyer, to analyze it equally carefully. MP does not go on bias, which answers my Lord's query, because in every case of a cabinet and every case of a governor, then MP must be read to mean it's a 6th category of discretionary power of governor. MP doesn't say so. Secondly, if my Lord's the clarificatory question was correct in the conclusion, then there will be no manifest irrationality. Which governor needs to go to manifest irrationality, Wallace? Doesn't need to. Your Lordship is not to waste your Lordship's time to go to manifest irrationality when it's presumptive bias.
It was only a clarification that.
No, I'm not saying your Lordship. I'm answering your Lordship's question. The governor doesn't have to waste his time. If he has, why should he examine manifest irrationality? So suppose, Balas, and there are 2 categories. One is, Balas, your Lordship has given me the category where which cabinet will go against. Of course, Balas, In politics, there are enough cabinets which go against me. It is not,
It is true.
so sanguine and so uniform as your lordship might think, these are very turbulent waters,
No.
to put it mildly.
Yes, sir.
But that apart, your lordship is not looking at the other aspect which my learned friends will, my learned friends are not looking at the other aspect which your lordship will appreciate. That cabinet, if it gives, forget this case for a minute. I'm testing your lordship, the proposition. If the cabinet in a hypothetical case gives perfect reasons, right, it says this chief minister has done nothing.
No, that's what the cabinet noticed in the case.
I'm not saying my case.
Yes.
Forget my case.
All right.
Hypothetical case, that this cabinet has said that this chief minister is always sitting at a 10-mile distance from all these decisions over 20 years. But in fact, it's a very unusual case. I mean, I'm going to be developing all this. It's a very, very interesting case, 23 years. In 23 years, at least 23 public servants must have been involved in this. The list of dates the lordship has got from my side and this side.
Yes.
One person is singled out by these complainants, 3 complainants, with somewhat dubious antecedents sketched in my petition. One public servant is culled out after 20 years. And in those 20 years, this man has been a minister from his 1984, I think he became a minister in the 80s. Across, he's held many portfolios. No particular portfolio on this issue, no particular file, no particular decision, no particular recommendation, no particular approval. Your lordship will not easily find a case like that. Your lordship finds. Now I can understand the governor saying, despite this, I find Mr. Singhvi's reasoning wrong by 1, 2, 3. But more importantly, apart from Mr. Singhvi's reasoning being wrong, I find that Mr. Siddaramaiah is complicit or is involved prima facie or needs to be given sanction prima facie because of ABC. He doesn't say it. He doesn't say it. He doesn't address the issue. Which brings me to the next point. And therefore, very important clarification. I'm very genuinely grateful for your lordship's query. 2 answers to that. 1, your lordship is not carving out a new category of presumptive bias. 2, MP, which is the only case relied upon for only by the other side, forget the other side, by the governor, is a case where they did not take up apparent bias in a cabinet governor case. And 3, it must show, therefore, a perverse 2 plus 2 is equal to 5 error amounting to manifest irrationality, which the governor has not said. He's not even said so. If he had said so, I would have shown he's wrong. But I don't need to show that because he has not said so. Now, which is why it brings me to my 3rd point. It is because of the previous point that my learned friends do something very extraordinary. That is, the state government. I'm sorry, the person representing the governor, not the state government, the person representing the governor. Of course, governor acts to the state government, but he is represented by a separate council. Very extraordinary thing. Keeping in view that there is nothing about manifest irrationality. There is nothing about any reason by the governor and nothing reflecting the process of ratiocination. A lot is put it very nicely in many judgments. These are the materials. That is the conclusion. The chain which links the material with the conclusion is known as the process of ratiocination, the process of reasoning. Now, there is no reasoning about why he is guilty, prima facie, or why the cabinet is wrong. The only reasoning is that the presumptive doctrine my lord put. Per se the cabinet, per se the chief minister, therefore I must act. Why I must act is not there. Which is why a 3rd point is pressed into service after the case starts. What is that 3rd point? Knowing that there is no manifest irrationality commented by the governor, knowing that he has not dealt with any issue about Mr. Siddaramaiah, knowing that he has not found any reason to deal with the cabinet itself. They say now, after the case is started, we will not file an affidavit. We will produce files. And I mean that like Alice, it gets more and more curious. So first thing is, I will produce files. Files are produced. Second thing is, in the files, there is only, if you will look carefully, a chart saying 2 versions. Version 1, version 2. There will always be two versions, Balas. There is hardly a case which does not have two versions. Life is all about, Balas, grey. Very rarely black and white.
Two versions in the minimum.
Minimum, if not 3, 4. Absolutely correct, Balas.
Multiple versions.
Our Balas, religions say that it's multifaceted use. There is no Balas. Relativity doctrine itself, everything is relative. Time and space is also relative. Balas. What about versions? Versions will be many.
Minimum two versions.
Minimum. He then, Balas, puts the two versions, and in the entire bunch, big fat bunch given to your lordships, he doesn't say anything except at the end, I think it should be given. But more importantly, none of the reasoning in the files by the lower officers, not one word is reflected in the impugned order. There is no law that I know of that you produce material and say you've deemed this sanction order to be valid, because at the back of my office, people gave me 5, 10, 12 versions with 1,000 pages of files. That is like saying that I will be the inscrutable sphinx. Behind the inscrutable sphinx, the pharaohs put a lot of gold and a lot of saman inside.
The silence comes about.
So I will remain the sphinx, but the saman behind in my grave can speak for Malas. It all lying in the...
That's right. Inscrutable face of the sphinx has something behind it which cannot be projected by that silence.
And your lordship as a judge should be deemed to validate the inscrutable face because of the saman behind it. But what is interestingly, that huge treasure house of saman is not finding a word of reflection in the order. Well, I can understand. Nobody is saying that the governor is a judge who's writing a 50-page judgment. Nobody is suggesting that. The governor could have given some reasoning culled out from those two versions and 1,000 pages. It is not for your lordships to rewrite the order of the governor. That I am the judge, you have thrown at me 1,000 pages, the order says nothing. I as the judge will ex post facto validate it by giving these reasons. Which ultimately comes back to the same point, Wallace. The point remains the same. That your lordships is entitled to quash this order on the short ground that it is not dealing with these issues. Neither manifest irrationality nor why. You are saying, of course, that there are reasons inside. But, Malas, and two versions is not a sufficient ground at all. Much more so, Malas, when you are disagreeing. You are disagreeing.
Yes.
You are not upholding. Your lordship knows, Malas. There's a difference. Your lordship judicial review is much more heightened when the primary matter is coming on a disagreement. Your judicial review is a little different when it's coming on an affirmation. So that was the third and fourth point, Malas, which I'll be developing. The other point is, Malas, about 17A. Now, Malas, there are two facets there I wanted to just touch on, then I'll be developing them later. Well, it's 17A is not, Malas, in any manner, 2 or 3 points. First, in 17A, the interpretation canvas for your lordship is to an extent, Malas, faulty and erroneous, is my submission by the other side. Why is that? A very broad brush blanket proposition is thrown at your lordships. Lalita Kumari test is 17A. I strongly object to that. Lalita Kumari test is not 17A test. In fact, it's very interesting. I've now investigated the legislative history of 17A. The idea of 17A was to provide a genuine, strong filter.
Yes, a protective layer.
Protective layer is the correct word. Filter is the correct word. And umbrella of protection is the correct word.
No, both are used. To protective layer to protect the innocent and not shield the guilty.
Shield the guilty. Correct.
That is what is
correct. Absolutely. But Balas, Lalita Kumari, born much later, can't be just read into 17A.
No, when 17A comes into the statute,
yes,
Lalita Kumari is 4 years before the 17A coming into the statute.
No, that's true, Malas. But the FIR test of Lalita Kumari could have easily been put in 17A.
Oh, that is not put anyway.
No, not only that. I show that, but in fact, the legislative history originally of 17A provided for the filter through the Lokayukt. That's very interesting. The idea was that I am now, Malas, not on the deletion because the first argument is deleted, which means the filter is on. That's not the argument. But what happened was that they went through very draft. I've got in my note, Malas. Broadly, it said it is a protective. They were emphasizing the protection. Otherwise, governance will come to a standstill. That's the whole idea of this, Malas. We have enough people, Malas, taking pot shots every time. And according to me, this is a classic case because after 20 years, your lordship has different kinds of. But The protective layer originally envisaged was A, a full substantive, and B, it had to go to a very detailed scrutiny, and they put the Lokayukt. Then they said Lokayukt will be a different institution. So we change it only as to the hooper, not the test. We change it to the government or the police officer. So the change is from him to me. The change is not of the degree or the heightened degree of scrutiny required. That's going to be my point. Then to dissolve it from that higher test into a Lalita Kumari test. Lalita Kumari test is a very, you should know what Lalita Kumari test is, at the end of the day. It is ultimately, you go and file something and you're supposed to act on that. That is, reducing the entire object of 17A. And then, I'm also going to be showing to your lordships that, and this, your lordship has a judgment on this, Shirupas, but I have a different nuance to it. I've quoted it as to the nuance. I believe, and this is going to be one of the arguments, that it is for the investigating officer to first form an opinion that inquiry or investigation is warranted. I'm choosing my words carefully. The investigating officer must first form an opinion that inquiry or investigation is warranted. I am the investigating officer, I form the opinion about him, and then I seek approval for that opinion, having that first form the opinion. According to me, to allow a outsider, a third, not out, let me go to third party.
Who is the third party here?
Third party,
the complainant?
Complainant.
All right.
The third party could be, outsider or complainant or whatever, third element. Or a stranger, to come into it is to actually remove a very significant part of that protective layer. Because I am the investigating officer, I form an opinion about him. I take it elsewhere for approval. Thereafter, people, it's not that it's the end of it. There are so many other remedies. But here, my formation of opinion is the first step. Approval is the second step. Before these two steps, the third party actually removes the protective layer altogether. That's the second error on 17A, is going to be my submission. And Shirupa is being wrongly read. The Lordship has not changed this law, according to me.